First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the first DCA. We have one case on our docket this morning, which is Timberview Helicopters versus Okaloosa County. That's our case number 242176. Counselor, are we ready to proceed? And before we get started, would the appellant like to reserve any time for rebuttal?
3 minutes, Your Honor.
3 minutes. So noted. You can proceed when ready.
May it please the court, Matthew Gutierrez on behalf of the appellant Timberview Helicopters. Your Honors, this is a straightforward breach of contract case. I'm going to start by giving a little bit more background than I normally would because I think it's important to frame the issues at the outset. Timberview conducted helicopter operations at the county's Destin Executive Airport, and its contract with the county contained 3 separate and competing termination provisions, each of which governed termination for distinct grounds and imposed distinct obligations on the county in terminating the contract. Section 16, which is generally referred to as the termination for convenience provision, allowed the county to terminate the contract with 15 days' notice, did not impose any additional obligations on the county in effectuating the termination, and it did not specify what grounds it applied to. The other 2 provisions did. Section 5 governed termination for late payments, and it said that the county had the right to terminate the contract pursuant to a delinquent payment once it was delinquent for 60 days. Section 18 of the minimum standards, which I argue is the provision that we're dealing with today, was the termination provision that applied when the termination was for violations of the minimum standards, which were a set of rules and regulations that were attached to and incorporated into the contract.
And I understand the 2 agreements and the attachments, and I certainly agree with your argument that the minimum standards were incorporated by reference into the operating agreement. But what record evidence is there that the termination was for violation of the minimum standards as opposed to violating the operating agreement, just an at-will termination, whatever other reason other than the minimum standard?
There is voluminous record evidence that the termination was actually for a violation of the minimum standards.
Well, Commissioner Ketchel and Mr. Strange said for cause, but they didn't say minimum standards. What else do you have? So
in the parallel FAA proceedings, the county defended its decision to terminate. So our position was this was a termination for economic discrimination against a certain type of aviation in violation of FAA regulations. The county's defense was that no, it was actually a termination for a violation of the minimum standards. If you look at the June 16th termination letter itself, it cites to 3 specific kinds of violations that are directly in the minimum standards. One is with respect to insurance obligations. That is an alleged violation of Section 16B and 12E of the minimum standards. One is an FAA letter of authorization, which is an alleged violation of 15E of the minimum standards. And another one is certification for vehicles carrying fuel, which is 13A of the minimum standards. So we submit that there was voluminous record evidence, and the county's own position in the FAA proceedings, its defense was that this was a termination not for a violation of something within the exclusive jurisdiction of the FAA, but for a violation of the minimum standards. So the trial court looked at this disputed evidence regarding the rationale for the termination because the county took the position that it was for convenience. There was voluminous evidence that it was actually for the FAA, exclusive jurisdiction conduct.
Can I go back for a second on your mention of the letter terminating, I've got from record 6890, a letter from Mr. Strange to Justin Johnson that said pursuant to section 16 terminates and, says they've got to be out and cease operations and such. Is that what you're referring to as the letter of termination, or is there something else that I'm missing?
I'm referring to record 206 through 207, and in particular 207. It says, finally, the county commission instructed that Timberview cure all outstanding breaches as soon as possible, but within 15 days at the latest. And then it listed 9 bullet points with breaches it said existed at the time contemporaneously with the termination of the agreement. And we understand, and it's undisputed, that the county cited to section 16 in terminating the contract. We believe that that's not dispositive. And it's for the same reason the trial court erred in determining that all the county had to do was comply with section 16's 15 days notice provision. If you read the contract the way that the trial court did and the way that the county is advocating, it violates 4 interpretive canons. It cannot be the case that no matter the actual reason for the termination, the county can always rely on 16E for 4 reasons. 1, that violates the whole text canon. Reading section 16 in isolation without reference to sections 5 and section 18 of the minimum standard ignores other pertinent provisions in the contract. 2, it violates the general specific canon. In our view, section 18 is the specific provision that governs because it outlines the specific grounds for termination that we submit are at issue here. Section 16 is a general provision, and under the general specific canon, the specific governs over the general. Number 3, it violates, it renders sections 5 and section 18 superfluous. So if any time the county, say for example, had a breach for a delinquent payment, under the contract, it wouldn't have the right to terminate the contract for 60 days. But if at any point during that 60-day period it decided to terminate for convenience, it could always obviate the need to comply with section 5, and we submit for the same reason. It would always obviate the county's need to comply with section 18 of the minimum standards.
What are we to make of the record from the BOCC, the transcript of the public comment, and then the motions that ultimately resulted in the termination? They talked about 15 days. It looked like Timberview's trial counsel even talked about 15 days. Ultimately, they gave 60 days to try to work something out, but it seemed pretty clear that there was not a discussion of minimum standards. There was discussion of flight overviews and problems with the flights and things like that. But I don't recall anybody saying they violated the minimum standards and therefore we need to terminate under the section 18 provision of the minimum standards as opposed to the section 16 provision of the operating agreement.
Right, so they did not specifically cite to section 18, and that's undisputed. They cited to section 16, and our position is that that is not within the control of the county. Timberview has vested rights in the contract under section 18 and section 5. The county can't pick and choose which provision it proceeds under because that would render the other 2 termination provisions superfluous. You have to read them together, and the interplay between the 3 competing termination provisions is what is at issue in this case.
Section 5 doesn't have anything to do with this, though, right?
Correct, but it's just another example. And the county, and the reason section 5 is important is because the county has now conceded that in the event, in terms of the example I gave earlier, in the event that there were a delinquent payment, the county concedes it could not terminate for convenience. It would have to wait the 60 days and then terminate if it were a ground specifically addressed by section 5 or any other pertinent termination provision. The county concedes it would have to proceed under that termination provision. The reason it says that that logic doesn't apply to Section 18, well, it gives two reasons. Number one, it says Section 18 of the minimum standards can't be interpreted as part of the whole text because it's not part of the text. The county's position is that that is a separate contract that is not entitled to consideration under the whole text canon. It says the Section 18 is part of a document that is parole evidence. That's incorrect. Two, it says that it turns the general specific canon on its head. It says that somehow the Section 18 termination provision is the more general provision and Section 16 is the more specific, and it says as between those two, the specific should govern over the general, and somehow Section 16 wins.
So, say we agree with you that this is a Section 18 termination, not a 16 termination. There was a requirement that they be notified that was an actual notice, but there was constructive notice in that the Timberview folks knew before the hearing that this was going to be discussed and had the agenda from the hearing. And then at the hearing, there was an opportunity to be heard. The Timberview owner spoke, his wife spoke, the attorney spoke. Nobody asked for more time. Nobody said, from Timberview said, let us come back and present more evidence to you. So why is that not sufficient for a Section 18 termination if that was the case?
Well, we believe that the notice, first of all, this wasn't considered by the trial court in its ruling, so to the extent the court wanted to explore the facts that were pertinent to that rationale, would have to remand and then ask the trial court to consider it in the first instance, because we believe that that's a factual question. The sufficiency of the notice and opportunity to be heard should be a factual question that would be resolved in the trial court. But I would like to clarify that Timberview's lawyer, Ms. Cole, objected at the hearing when she began her presentation at record 3250. She started by saying, if we had more time, we could have prepared a presentation to address all of the alleged violations that were pertinent to the county's decision-making process that day. So there was an objection to begin with. We submit that there was no constructive notice or direct notice provided to Timberview. What happened was, on June 10th, Timberview's representatives met with Commissioner Ketchel and Director Stage in sort of a private meeting to have a discussion. At the end of that meeting, Director Stage cryptically, in our view, like in a threatening manner, said, "I've got something coming for you." That comment, that cryptic comment, prompted an independent investigation, which ultimately led to Timberview discovering on its own, just days before the meeting occurred, that they were on this agenda item and the potential termination was going to be discussed. They sort of scrambled to try to figure out what to do. They did attend a hearing. They were provided 3 minutes to defend this voluminous list. And as I mentioned, Timberview's lawyer started her comments at the presentation by noting that she did not have enough time to prepare a proper response to all the individual issues. So I'm eating into my rebuttal time, Your Honors. For the reasons stated in the brief, we submit that the entry of summary judgment for the county was erroneous, and we ask the court reverse and remand to the trial court for further proceedings, and I'll reserve the remaining time for rebuttal.
Thank you, counsel.
May it please the court. My name is Greg Stewart of the law firm of Neighbors, Gibble, and Nickerson, representing Okaloosa County. Initially, it's our position that there are no material disputed facts and that the court properly granted summary judgment in this case, and finding that the Board of County Commissioners in the termination of the operating agreement followed all of the requirements of that agreement. Let me go initially to the questions you had raised about the supporting of the record. There is nothing in the record that reflects that the minimum standards was any basis for the action in terminating the operating agreement. As reflected by the transcript and the agenda item which accompanied it, the board discussed issues relating to the operating agreement and whether that agreement had been sufficient to protect the county's interest over the years. If you review the transcript, it has documentation of the fees paid. That's Section 2 of the operating agreement. Right to audit by the county. That's Section 8 of the operating agreement. Control of passengers, Section 13 of the operating agreement. Flights at night, which were prohibited, another Section 13 provision. A general lack of cleanliness, Section 14 of the operating agreement. Documentation of insurance coverage, Section 10 of the operating agreement. All of those are specific issues that were raised as far as the operating agreement and whether the activities of Timberview were meeting those requirements, or did the agreement need to be modified, which is ultimately what they voted to do. None of the issues that I just mentioned or that were brought up at the June 15th board meeting addressed any issues within the minimum standards. It's important in looking at the minimum standards that that was adopted or created in 1997.
But would you agree, though? I mean, it was created in 97, but Section 11 of the operating agreement says such minimum standards attached herewith and made a part of this operating agreement.
Yes.
So it's one unified contract then. It doesn't matter when they were made, it seems to me, if they're part of the operating agreement.
No, I agree. And my point in this is that what the argument of the appellants is that this, in interpreting how these different agreements that have been incorporated together should be applied is in essence saying the operating agreement that it was prepared in 1997 should supersede a negotiated agreement between two parties, because that's exactly what they're asking to do. But I think it's important if you look at the minimum standards in relationship to what Timberview's situation is, because they are a special services operator. If they have sightseeing activities, that's governed by Section 12. The requirements that go along with an operation under Section 12 are extremely limited. They have to provide pilots to support the public demand, provide planes to support, or helicopters in order to provide the public demand, be open to provide the demand. These are very generalized requirements and not specific in terms of what they really are operating. It pretty much leaves it up to them. So in talking about these minimum standards and whether they were considered, it's important to understand there really is very little standards within the minimum standards relating to Timberview. Additionally, it is important to recognize the language of the minimum standards itself, which primarily governs fixed-based operations, the main manager. There's very little in there to these other accessory type operations like the helicopter, and it is kind of almost included by just a reference, but very little regulation. But when you look at that's the only area that within the appellant's brief that they were even able to cite as within the minimum standards, they attempted to argue that the insurance requirement was what was being addressed. But if you look again at Section 12, all it says is that they will provide some type of insurance. The operating agreement is the agreement that spelled out the details when the parties were negotiating. And so that is what was being addressed. It was whether they were bringing in helicopters and whether they had insurance coverage for those helicopters as they were coming to use the Destin Executive Airport. That was the problem. That's covered by the operating agreement. Nothing in the minimum standards addresses that. The notice of termination that counsel read, I agree with the court's question there that it really does address the termination of the operating agreement under the provisions of the operating agreement. And the various activities that were referenced in terms of cure are all related to the issues that had been noted during the public meeting as to failure to comply with the operating agreement. And so there really is not bringing in the minimum standards in that particular reference either. I want to touch briefly on the hearing. The hearing on June 15th of 2021 was conducted in accordance with the policies that have been adopted by the Board of County Commissioners. Under Florida statutes, section 286.0114E allows the county commission to establish procedural standards, including the amount of time that people can speak to an issue. All of those were established many years prior to this hearing and have been applied consistently since then. And as the court noted, nobody objected to the amount of time in terms of it. And in fact, counsel for Timberview spoke far longer than 3 minutes because he was able to make a presentation, and then the board allowed him to answer questions that they might have as to the Timberview issue.
In that regard, the ability of Timberview to respond, it's a big record, so I'm not exactly sure where this comes from, but I've got what was labeled Composite Exhibit G on Record 199 that's, I guess, a letter from Mr. Johnson to Timberview outlining, Mr. Stage states in paragraph 3, sentence 4, that Timberview is represented ownership. Correction is that Timberview does not have ownership, and so on. And it goes line by line and refutes various allegations that Stage has made. Do you know, and I know I'm asking you about an 11,000-page record, but do you have any idea where this may have come from, and was this?
My recollection is that following the June 15th hearing, counsel for Timberview put that letter together and then submitted it to the board, so they would have that as part of the record. I don't believe it was at the meeting.
So this was after the vote was
taken? That is my
So
recollection.
it shouldn't have any bearing on whether there was a sufficient opportunity to be heard either way?
No, and I guess whatever relevance it might have in terms of the future negotiations that they were entering into, but I don't think at the
Okay,
board.
I appreciate the clarification. I was just wondering, if that had been submitted before the hearing, then obviously that would be some evidence that there was further evidence of an opportunity to be heard.
I do want to touch a little bit on the finding by the FAA. Council's referenced it a couple times.
Before you jump into that, can you address section 16 and the basis for termination there? What limitations, if any, are there for the county to exercise a termination under section 16?
Well, I mean, it is as they say, a termination for convenience. And the only requirement in terms of procedurally to exercise it is that, in fact, they have to give the 15 days written notice prior to termination. However, the minimum I do not believe that they could terminate for a violation of the minimum standards. I think that the county would have to utilize the requirements for under Section 18 if they elected to terminate for some basis that is contained within the minimum standards. And
So
that's
if they're
why the
concerned
record is
about-
important that there was nothing that addressed the minimum standards.
So if they're concerned about issues with the minimum standards, they can't just say, well, we're going to just do this for convenience because it's maybe more convenient for us to not do it under the minimum standards provision.
I believe so. I mean, the county has created this standard or policy, the minimum standards, and they have set a certain procedure for a violation of that. And in fact, it's important in terms of this particular argument that the minimum standards themselves make it very clear that they only apply for a violation of the minimum standards. And so to now transfer that and say, well, you have to utilize that termination provision, Section 18, in lieu of Section 16, that disregards the express language. But I do believe that because the county has established a separate policy for those violations, it would be obligated to follow those.
So it could be for convenience except for things under the minimum standards provisions.
Well, if in fact that is the reason that they terminate and under the minimum standards, I believe that they would have to use Section 18.
Does that put any kind of burden on you to demonstrate that it wasn't a termination based on the minimum standards?
Well, I don't know whether I'd characterize it as burden. I think that what's important is the record. And the record demonstrates convincingly and overwhelmingly that, in fact, the issues that were being raised and concerned of the commissioners dealt with specific provisions of the operating agreement, not the minimum standards. That's where the other comment that I previously made in terms of what are those requirements that they are saying that the board considered. They're very limited, if any. And so I think when considering what would be a violation under the minimum standards and then what actually happened demonstrates clearly that, in fact, the minimum standards were not the basis of any action by the board. Going to the FAA issue, first of all, the FAA does not deal with contract issues. And they never addressed, and in fact specifically said they didn't address the contract issues. What the violation was found was because of a grant assurances issue from not entering in the new agreement. So to the extent that they are trying to bootstrap the FAA finding as that some relevance to this case, I think is flawed.
I took their argument to be that they're claiming that the implied covenant of good faith and fair dealing that's inherent in every contract was violated in part by the FAA violation. What would your response? If I'm getting that argument right, what would your response be?
Yeah, well, I think that the principle of implied covenant of good faith, I mean, I agree that generally applies to all contracts, but it does have to have some breach, and there was no determination of a breach by the FAA as to the prior contract. The issue was what they monitor is the activities there to make sure that grant assurances are satisfied, and that dealt with the subsequent agreement. And I think that it's clear that the county has the right under the operating agreement to terminate that agreement for convenience or in its own interest. And there has to be some type of breach, and there is none in terms of the operating agreement. So the covenant of good, implied covenant of good faith, I do not believe is applicable in this case. One final, at this point, I'll rely on the remaining arguments contained in our brief, and we would ask for the court to affirm the trial court's decision granting final judgment to Okaloosa County. Thank you.
Thank you, counsel.
Your Honors, I have a few brief points on rebuttal. My colleague on the other side has now conceded that if in fact the termination was for a violation of the minimum standards, that the county would be obligated to proceed under Section 18 of the minimum standards. But my colleague on the other side claims that there is no evidence in this record that this was a termination for violation of the minimum standards. Look no further than their own words in the FAA proceedings. I'll direct the panel to record cites 7441, 7453, and 7454 through 55. And I'll read one excerpt out of those three. Quote, the county argues that Timberview's commercial operations were terminated from the airport not to restrict noise, but because of violations of the minimum standards. That's the county's position to the FAA. It was defending the termination of the agreement under the ground that it was a violation of the minimum standards.
You're saying there's some sort of collateral estoppel or,
We're not arguing collateral estoppel. We're not sure that has not been fleshed out in the briefing. We're not sure that the issues were identical, but at a minimum, it is an admission by party opponent that they have relied on a violation of the minimum standards seemingly as their primary defense in the FAA proceedings.
Can I ask you before we go through all your time, is there any other provision of the minimum standards other than Section 12 that applies to Timberview?
Yes, so the county said only Section 12 applies to specialty service operators. In fact, if you just review the text, it's sections 11, 12, 13, 15, and 16, all either directly or indirectly apply to specialty service operators. The county says that the insurance obligation, this one's very important, the insurance obligation was only with respect to the provision in the operating agreement, not the minimum standards. If you look at the provision in the operating agreement with respect to insurance, it talks about premises liability. It says that before Timberview can move into the airport, it must obtain premises liability insurance. The complaint by the county was about individual helicopters going on and off site, and the insurance that covered those aircraft. Only the minimum standards, Section 16B, talks about insurance coverage for aircraft liability. That is uniquely an obligation under the minimum standards, not the operating agreement. And my last point, Your Honor.
Can I ask you about that? The operating agreement, I've got Section 10 here of the operating agreement. Operators shall provide a current certificate of insurance prior to occupying, reflecting aviation premises liability, $1 million, property damage, $100,000. So with your general specific canon that applies, wouldn't that be the more specific canon in the operating agreement as opposed to the more general language in the minimum standards?
We disagree, Your Honor, because the complaint by the county was not about certificates of insurance for premises liability. It was about certificates of insurance for individual aircrafts that they claim came onto the premises without insurance. Again, Section 16B of the minimum standards specifically governs aircraft liability, not premises liability. So we submit that the more specific provision pertinent to that issue is Section 16B of the minimum standards.
I'll let you go ahead and sum up.
Thank you, Your Honor. So for these reasons, we respectfully request that the court reverse the entry of summary judgment and remand for further proceedings in the trial court. Thank you.
Thank you, counsel. Thank you both for your arguments. We appreciate it. With no further business, we are adjourned.
All rise.